Welcome to WOW, Voice of Values. The new criminal major laws, which is Bharatiya Nyaya Sanhita, Bharatiya Nagarik Suraksha Sanhita, and Bharatiya Saksha Adhiniyam have come into play on July 1st, 2024 by repealing the Indian Penal Code, the Criminal Procedure Code, and the Indian Evidence Act. We have Mr. T.K.Sridhar, a prominent advocate of Telangana High Court and the Supreme Court, with us to discuss and converse and to elicit the important insights of the criminal major laws. And he is with us today to enlighten us on the various aspects of the changes in the sections, the names which have been, the titles which have been bought with the Bharatiyata, which is eradicating the era of the British rule. So let us talk to him and let us all know about the changes which have been taken in the criminal justice system. Namaste, sir.
Namaste.
The name Bharatiya Nagarik Suraksha Sanhita, Bharatiya Nyaya Sanhita, and Bharatiya Saksha Adhiniyam has the word Bharatiya in common. So, sir, according to you, do you really think that the British colonial era has been eradicated completely with the changes which the new laws have undergone? Or do you think that just the title has been changed and the entire essence of the criminal laws have remained so?
It's a very good question. First of all, we need to understand, earlier the wording used was Indian.
Yeah.
Indian means a territory, a place. Bharatiya or Bharat is also a place.
Yeah.
Bharatiya means the people of that nationality. So we need not have a much quarrel about the title. But the question comes is, the constitution is very clear. All the titles or enactments should be in English only. Because the India is a composite culture where we have people in southern India, we have got people from Orissa, we have got people from West Bengal. They may not be conservant with the Hindi language. And also there is an opposition for imposition of Hindi.
Yeah.
Whatever may be the reason, but you had another question whether really it was meant for taking away the colonial impact. First, we need to understand what is colonialism. Colonialism is establishment of colonies by the erstwhile Portuguese or Britain or Sweden or whoever. They maintained some colonies to have their own business deals. The first and foremost is being the East India Company, which established the colonies. All of us know. In the First World War of Independence, when it took place in 1857, Queen Victoria has taken over the administration from the British India, from the East India Company, and it slowly went into the hands of the Britain, Queen of Britain. Then the colonialism question comes. 1860, the Indian Penal Code was formulated. After reading the various laws pertaining to both Hindus and Muslims or whoever it is, and they codified it. They codified it in such a way, and the codification was very simple. It contained the explanations, exceptions, then right of punishments, right of private defense, offences against the state, offences against the government, offences against the public, offences committed against the public servant, offences committed by the public servant, offences against public tranquility, offences against the human body, offences against property, offences against mind and reputation. So section 44 of the erstwhile code defined what an injury is. Injury means injury, illegal harm done to mind, first human body, property, mind or reputation. So the classification of the code was very clear and easily understandable.
Right.
Now, by virtue of Bharatiya Nyaya Samhita, the explanation part has been reduced.
Okay.
And exceptions were retained. Punishments are retained. Whereby some of the sections which need to be explained in the beginning itself, because the code contains a serious consequences will flow when you are punishing. So unless you know the meaning of that act done by him, it is very difficult for the courts to come to a conclusion.
Yes.
whether really the offence has been done or not. Then there is a significant change in the Bharatiya Nyaya Samhita. Offences of the body were coming from 299. All of a sudden, this focus has been shifted by giving priority to the offences committed in a sexual manner.
Yeah.
So, sexual offences came first, then came the body, then came the important provisions according to them is of organized crime, terrorist act, and petty crime. So the entire focus has changed from the very understanding of the code where the bodily offences have been preceded by the sexual offences. And for offence against a child, if any person commits an offence against a child of 12 years, POCSO Act is there. Here the death sentence has been will be awarded. That is the sum and substance of the offence. So there are certain areas like sedition. Sedition earlier, it had a colonial mark. So people were saying if anybody speaks against the government, it amounts to sedition. So the key word to be used is disaffection against the nation or the national integrity or against the government. Established order. You are doing some act where you are destabilizing the nation, it amounted to sedition. There was a challenge even before the Supreme Court with regard to sedition. When the challenge is still pending before the apex court, now the entire wording is being taken away. Now, so that is a major areas where we can understand with regard to Bharatiya Nyaya Samhita. Next, the question to be answered is whether really it was colonial or not.
Yes.
We got independence in 1947. And in 1950, the Constitution of India came into operation. Article 13 of the Constitution has divided into three or four articles, subclauses, where it clearly said, whatever laws which were made prior to the Constitution, if they are offensive to the fundamental rights, they are void ab initio. If any laws which are made, which are consistent with the fundamental rights, they are saved. Yeah. So, it means in 1950, there should be a challenge that these laws are all colonial.
Right.
So, once you have protected and saved those laws, you cannot now plead they are colonial. Why? Because it has passed the test of constitutional validity. So, all those laws, whether just because it is made in 1860, it doesn't mean that it is colonial. Whether it is giving some benefit to the people or punishing the wrongdoers is the question. How the punishment is being done, how the court is coming to a conclusion was important. So, 1860. Second question is Bharatiya Nagarik Suraksha Samhita. 1898 was the earlier code. So it had lengthy procedures where the committal magistrate had so many powers and it dealt with so many other irrelevant areas. You have, after going through with the various recommendations of the law commissions, you have repealed the old code in 1898. So in 1973, Indians are only ruling now. Where is the colonialism involved in it? So 1973 CrPC, you have repealed it, whereby you are saying in the parliament, you have taken away the colonial legacy. So in 73, Indians are ruling or British are ruling? The question is now, by undoing the Criminal Procedure Code, you are losing the wealth of the judgments which has been interpreted by the apex court on various human rights, because in the process you have removed the focus on Article 20, 21 and 22. So the procedure established by law is totally changed now. The entire interpretation, right from if you are depriving a person of his personal liberty, of when you are going to arrest a person, the timing of arrest, the remand, everything, the wealth of information from the Supreme Court decisions, the principles of law, the ratio descendi was available. Now, by upsetting the procedural law, you can do anything in substantive law. In procedural law, if you meddle with it, what will happen? It will have a serious impact on the administration of justice. And you brought in two important provisions, whereby in the FIR, registration of FIR itself, how it has to be registered and everything to be digitalized, and the police officer should carry one
Camera.
mobile phone with him, and he must consult the forensics. Earlier also forensics was there. Section 45 of the Evidence Act clearly dealt with the expert evidence to be taken. So by just saying, and you have come in with so many dimensions of it. Now Section 29 of the Indian Penal Code mentioned what a document is. It also included the Information Technology Act. It has included in the word document, they have included the information technology, all computer, laptops, everything has been included. So what is the change about it? You have already amended the word document earlier in Indian Evidence Act and also in the Indian Penal Code. So by giving a separate provision to it, it doesn't make any sense. So your focus was getting the evidence from the electronic mode. You are giving too much precedence to it. But whether that electronic mode, whether it is possible in all occasions. Recently, the first case, Goa police have registered a case in Goa where two friends were fighting they had a differences with regard to one bottle of intoxicant or some whiskey or something. One friend has purchased and he kept with him. Another friend has taken that bottle from him and he has drank that. So the friend who lost that bottle of intoxicant, what he did? According to the police FIR, he was beaten by a stone. Now, nobody in a premises where the construction was going on. Now, in such a situation, what is the evidence rule applies? In a cases of direct evidence, motive becomes irrelevant. In cases of circumstantial evidence, motive plays an important role. Now, by bringing the digital evidence, the court is saying, the code is saying, you should collect digital evidence. How the offence has to be proved, and how it can be practical. Anyhow, earlier also for inquest panchanama, sending the body for postmortem, these were done. So by giving a very big wording, the essence of law is not changed. So almost all the provisions remain same. And with regard to Indian Evidence Act also, they have brought in this section. And the whole problem comes when you are filing the evidence, the proceedings will be done in open court, and the judge is also supposed to record.
Yeah, trial and proceedings also have to be
in
recorded
version. Now what will happen? The entire approach of taking copy applications, signing will go. Now, of course, the court will have an opportunity to assess, in appellate stage or otherwise, opportunity to assess the electronic evidence. But whether we have that wherewithal, so all these are the major issues. We can, over a period of time, we can discuss about each and every provision which is going to affect. In general, the question is, there is nothing colonial is not a reason for amending. If you wanted to amend the procedure, there are two important cardinal rules of criminal law. The prosecution should prove the guilt of the accused beyond all reasonable doubt. And second, the benefit of doubt, if it is there, it shall go to the accused. Now what the latest criminal procedure code, it is totally from the victim-centric point of view. So accused is already presumed to be a guilty person. So his chance to prove his innocence is not there. And you are under an impression that by bringing the digital evidence, the accused, whoever has participated, will be caught. Of course, this will be very useful in matters of writing or somebody doing some action against the state.
Writing
or
has
in
been repealed now.
Writing is not
Repealed?
taken away, but they have put it in another provision,
Dimension, yes.
and under organized crime, it has come as an organized crime. In such a circumstances, if the media or police collect an evidence as who is throwing, what will happen in cases of against public tranquility, somebody who is not present at the scene of offense will also be brought in on oral statement or on confession of co-accused. Now, in such kind of cases, if there is an evidence which is coming forward by way of a photographic or videographic evidence, the person is gone forever. So, he will be convicted. So, there are certain good things also. That could have been done by a small amendment. Of course. Okay, you have brought it from the victim's person's view. Criminal law has got 4 dimensions. Dimension number 1, the criminal law deals with police, powers of police, their power to arrest and power to remand, power to do the investigation, which is unfettered, cannot be interfered even by the court. Second agency of the criminal law is the prosecution agency, that is public prosecutors up to small level to that of the High Court. And Attorney General may also act as or a Solicitor General can act as a state counsel. Then comes the criminal law deals with the court, the powers of the court, how they are going to try, how they are going to summon, how they are going to assess the evidence, how the witnesses will be called for, and how many questions or how the cross-examination will be permitted. All these questions will be dealt by court. Fourth comes the prison department. So first comes police, then comes prosecution agency, third comes court, fourth comes prison. And in between, who has set the law into motion? The victim and the accused. So victim and accused, the interplay in between them is the offense. Whether the offense is done or not, then how the investigation has to be done. Offense may be done, but the investigation, how you are establishing the guilt of the accused while investigation or in the court or in the appeal or whatever stage is how the procedure contains. So procedural law is the handmaid of justice. So the procedure should be in the touchstone of the constitutional scheme. It cannot override, it cannot take away for the emotions. You need to be very careful while drawing a procedure. It leads to confusion. Now, recently in Delhi and Goa, 2 cases have been launched. One case against a hawker in Delhi,
Right, first
under
FIR.
offense under 285 of Bharatiya Nyaya Sanhita. Earlier also that was an offense. It was a cognizable offense, punishable for 200 rupees. Now see how it becomes a police state. Or the criticism it is going to become a police state. How the police have experimented? First they have taken an action against a hawker and it is a cognizable offense. So he can be arrested, but it is bailable one. If you are going for a 41-year notice, the law says only for non-bailable cases 41A or the present enactment, whatever is the provision is there, that can be invoked. For a bailable offense, now the accused can be arrested and he can be let off on bail. 5,000 2 sureties. So earlier in the court they were giving the sureties. Now the police will insist for 5,000 2 sureties. A poor hawker now is fixed, and what is the minimum punishment? 5,000
rupees.
And it can be, if it is a petty offense, then there will be community service. So he will be doing the business for his livelihood and he will be going to community service. So whether that is the intention of the law? Now, to prove that case before the courts of law, it may be a summons case also. Now police has to take a photograph of where he has put up the shop, how he is disturbing the public way, what is the net impact of it. Contrary to that, how this is violative. There is a Street Vendors Act 2014 which has given some powers to the state governments and allowing the hawkers and others to have their survival. Now, that is their right to livelihood. You have penalized it. So, in that process, this will become an act wherein thousands of hawkers will be there and thousands of complaints if they are put up. What will happen? You are criminalizing something which was not intended. It just stayed in the statute. Now, 5,000 rupees, what is his lively per month income? Maybe around 10,000 rupees. 5,000 you are penalized. Then he falls under repeat offender. Next time he does. So, either he will be going to the community service or before the police. And it will be a burdensome for the police to establish. And the timelines you have given, within so and so time you must investigate. So, this is how the procedural violation by the police will be taken advantage, and you are expecting that hawker to defend himself and stand in the court of law, either pay fine or to contest. So this is a very great threat which will have an impact on becoming a police state. Second, earlier the kidnapping, terrorist atrocities, there is a special enactment. Section 4 of the earlier Criminal Procedure Code distinguished between a general law, that is IPC, all investigation, inquiry and trial should be in accordance with the Criminal Procedure Code 1973. By now, what you have done, for special enactments, there is a separate special procedure which is to be followed under 4.2. Now, you brought TADA, the terrorist act here, organized crime here, petty organized crime. So it leads to confusion. Which agency has to now investigate? Whether that act you have not repealed, whether an offence will be investigated by the local police or it is to be investigated by the person in the special enactment. You cannot try a person for two times.
Yes.
So it will be a constitutional question. So by undoing something, you have missed the treasure of wisdom given by the apex court, and in that haste, maybe to speak to the galleries to say that we have done something very, very, very Bharatiya. Instead of it is becoming a Suraksha Samhita, it has become a Araksha Samhita for the citizens. So tomorrow, people will be under sufferance. Again, there will be new interpretations.
New judgments will
come
into play.
There will be clash between the old school of thought and what is the modernity you are, except bringing the digital evidence into format. How you are going to store. Suppose, now earlier, there was interference by the political personalities in registration of FIR and deleting the names of the accused. Both. Now, if an FIR is given against a person, if there is a digital manipulation by the police, what will happen? And what is the impact of those evidences which are manipulated? What is the procedure for fabrication? How you have to file a complaint for another case in Delhi High Court recently in between two companies with regard to trademarks rights. The Delhi High Court has interpreted section 531 of the CrPC, the Bharatiya Nagarika Suraksha Samhita. Sanhita means code. In Hindi it is Sanhita, it is not Samhita.
It is Sanhita.
Sanhita means code. Code means something which is in a proper order, exhaustive order. So the Delhi High Court interpreted, the old law will apply, and the Honorable Judge has initiated, the person has given, fabricated the newspaper advertisement, and the other side has filed an application under 340. The court said the new act will not apply as of now because it was done for the earlier to the July 1st. It has ordered for 340 application. So there is another interpretation. So many hundreds of courts will, whatever courts we are having in India, they will interpret the Sanhita in their way. Or all the three enactments. There has been, and we should not forget another important matter. CrPC, IPC are in concurrent list. So now states will also have got a right to amend.
Right.
First and foremost amendment which took place in 1989 with regard to 354 outraging modesty of women. Earlier, the punishment was only 2 years. In state of Andhra Pradesh, it became 7 years. After Nirbhaya incident, the entire interpretation has changed. Now each state will look the matter from their own perspective, and they will again tinker with the law.
Right.
So what is the Bharatiya involved? So maybe Bharatiya, okay, that name may be okay. But don't use words, it is wiping out colonial. That is too stylish to say. So we should not never make such statements. After 100 years, then this will also go, and they will also,
Something new will
somebody
come up.
will say, this archaic law has gone. The only protection is every 10 years or 20 years, there should be revision of law and how the system is functioning. Only to that extent, you must concentrate. How many convictions are there? How many trials are there? What is the docket explosion? Whether the proceedings are going properly? Whether lawyers and the law students are properly equipped to know? Whether the process of law is being carried by the institutions? All these things should be kept in mind. So that should be the focus. Okay, they've changed. We'll see how things will change. New interpretations and new
Judgments.
opportunities for the learned lawyers to get their deserving fees. Because earlier there was some methodology of earning. Now the entire focus changes. Now the client, victim, both. But another important facet. Instead of depending on police for all these things, the lawyers in general should know how to lead the private complaint procedure. So dependency of police, because police are busy with giving protection to the parliamentarians and the local legislators. So their main focus is to save them from attacks. So the lawyers should raise, the law colleges should teach the private complaint procedure, and the judicial academies should teach, because there is no need for some cases. For some cases, there is no need for police interference. Our colonial psyche is, if police come and handcuff, then you get some satisfaction. Whether he's convicted or not is not important. So with that focus, if the lawyers and the public at large, in offences up to 7 years, if they can go and file a private complaint, it will lessen the burden on the police. Police should be given cases of murder or narcotics or something which is of terrorist. All those things police can do. In matters which deal with civil dimensions, what is the need for police? Except for settlement.
Right, true.
Except for settlement. And for which you say, what will be the documentary evidence presented there? So, and there is another challenge with regard to remand also. They have extended the remand to 60 to 90 days.
90 days, yes.
And in police custody, which is against law. 15 days was the time period. Now it is going, the statute is confirming.
Even the human rights are affected sometimes with the custody.
Human rights are absolutely affected. You say the confession before the police is inadmissible. For 30 days, there is no discovery.
Entire constitutional validity is in stake now.
Now stake. But it all depends on point to point, provision to provision. Then each and every provision will be challenged according to the need of the situation. Then there will be new case law. Then old case law and new case law, there will be a confrontation. Conflict and confrontation. And with regard to offences pertaining to offence against minors, there is already a special enactment.
Pokso.
Why you have brought this here? So why this jumbling, why this confusion? And
it is becoming an infantile
no, but the
concept,
sections
just like
have been
the
reduced.
Constitution.
Sections have been reduced. See, earlier the enactment was, it was giving a definition, it was explaining, and the punishment was there, and illustration was there. Now you have brought 10 provisions like writing, organized crime
into one section.
One section. So if a person, where he falls?
Sometimes he might be elevating himself to a bigger crime.
Unknowingly, if judge commits an error and there is a minimum punishment is prescribed, that man's life is gone. So, if a person has committed an offence, depending on the gravity, there can be punishment. You are going for a deterrent theory or reformative theory. On the other side, you say, we will, other day, the Telangana government has given Kshama Bhiksha to the prisoners. So why this is going on is it is the responsibility of the state to maintain law and order. The victim is the state. Victim becomes a de facto complainant, state becomes a de jure complainant. That is the reason the focus is on the police and the institution, that they will get them justice. But general public at large are feeling, the victim is feeling that he did not get justice. The under trial accused is feeling that he did not get justice. And lawyers are feeling they are not getting justice. And 2 or 3 adjournments, second adjournment, there is no adjournment. Suppose the lawyer does not cross-examine, that evidence become against the accused. He is gone forever. The mistake of a lawyer, he will lose a valuable right. Statute does not, there is no other way to interpret it. 2 opportunities were given, you did not ask. If some judge wants to convict, does not permit more than 2, what will be the net effect? He cannot also give any adjournment. So that situational analysis is lost. Now again there was a challenge before the Supreme Court very recently. When the enactment was supposed to come into force on 1st July, somebody from Delhi only challenged the enactment by giving certain reasons. But any court, see, even the challenge can be made in any high court also, not only Supreme Court. Under Article 226, a statute can be challenged. Any legislation can be challenged only on 2 grounds. One, there is no legislative competency for such legislature to frame such a law. First point.
Right.
Second, it is so arbitrary and against to the part 3 of the Constitution. So first is test that whether the Parliament had legislative competency to pass such a law is already, it can be easily answered. It has power to frame a law.
Right, but there wasn't any discussion which has been taken in the parliament.
Can a court go into the parliamentary debates? When a bill, what is the method of passing a bill? Bill will be discussed, it will be moved by certain persons in either Lok Sabha or Rajya Sabha. Then there will be discussion, and by the majority it will be passed. That bill will go to the concerned president or governor. After appending his signature or her signature, it becomes an act. So whether court under 32 or 226 can go into the debates of the house. So that is a very vague argument. But what they can say is there should have been a discussion, because the bar councils has to play a very important role. Any legislation which is going to be passed, that legislation objections are called for from the bar councils. They have to play a very vital role. After passing the enactment, it is very difficult. Only option left for any person is to challenge in 2 facets. Either he should be a person who is aggrieved, or it should be in pro bono. If you are going in pro bono, the court will dismiss it. On what grounds you are challenging a penal statute? The reasons and objectives in that statute is for controlling some mischief. So in what way you are concerned, the court will dismiss it. If it is pro bono, he should be a victim or person aggrieved. That stage has not come. So there may be a challenge in various courts also, depending on a situation. One being the proclamation. In proclamation of an offender, the trial can be without his presence. What does the law say? Any evidence which is taken, it should be in presence of the accused only. So there may be a misuse. So there may be misuse with regard to taking of evidence. The concept, and another important provision in Nyaya Samhita is, in matters pertaining to women, almost all YouTube channels are giving so many statements, they are discussing. Now without permission of the court, if the proceedings are published, the publisher is punished, unlike defamation. So there is a risk of use and misuse. You cannot, at that stage, you cannot say, I've got right of freedom of speech, press is the 4th pillar, foundation of the democracy. All those things are not available. Now the law is there, curtailing your activity. And it has a penal consequences. Once there is a penal consequences, the touchstone, the total interpretation of that section, substantive law, should be seen from the methodology of the procedural law. So procedural law, how it is being done to do substantial justice with the background of constitutional law. So in that context, these laws, some parts of the laws are very good. Definitely it will have a deterrent effect. But if it is misused, it may increase corruption. It may increase corruption of various wings, and the person who is accused may not even come before the person who is charged. He may go for other methods to get away from the rigors of law, or he may go to the extent of, because there is no escape route, there will be other offences to prevent that. Suppose he is going to be convicted, then what that fellow will do? He will go for other methods of trying to purchase the witness or the concerned authorities. So it will lead to other offences also. So in nutshell, what I feel is that this is what I wanted to share my views with WOW.
Thank you, sir, for throwing a light on the new criminal major laws and the intricate detailing of how the criminal justice system will be in stake, and the constitutional validity and the authorities of the pillars of the criminal justice system would misuse the new amendments, or the
may misuse.
May misuse. Yeah. Thank you so much, sir. That's the episode on the new criminal laws. If you haven't yet subscribed to the YouTube channel of WOW, Voice of Values, do subscribe, do like this video and share it to your friends and family, and whoever who are associated with the legal field. You can share it with the law students also. Thank you.